Honourable Beesley, your 10 minutes begins now.
Thanks, Chair. I've never used up my time, so I hope the RAF don't give lengthy answers. I mean, not RAF, the legal counsel. So just a comment. I mean, it's quite clear based on the Hawks and the SIU investigation that our justice system is actually broken, and it's impacting on criminality, civil cases, commercial cases, and it's just getting worse. And obviously, the RAF are playing a role in it. So I'd just be interested to know what recommendations you guys have to improve the efficiencies from the side you're sitting on in terms of the RAF. And please don't use all 10 minutes to do that. But maybe, Chair, if they can, maybe it forms part of our recommendations of an inquiry how we can actually improve the efficiency, because it's having a huge impact on the justice system. And then you mentioned that you've got 800 cases per one caseload per one worker in Gauteng. I mean, that's an incredible amount of cases. It's worse than the Hawks. And how do they decide, and how do you decide which case gets prioritized? Is it in chronicle order, or is it based on value, whatever? And then just to capacitate me, and I'm certainly no expert, does every accident lead to a claim? How is it calculated, and what is the average claim? And then just in terms of that 350 million that was paid to 101 lawyer firms, am I correct to say that they were sitting in that money and they didn't phone back the next day and say, we've got this money? Because either lawyers get paid a huge amount, and so if you work it out, it's about 3 million rand each. So surely every single one of those lawyer firms should have been disciplined, because to be sitting with that amount, if I get 3 million in my bank account tomorrow, I can't sit with it. I have to phone my bank and say, there's an error here. So surely, you know, to only 12 people to be, I don't know what the exact figure was, to held to discipline. I mean, everyone should have been held to discipline. And the fact that they didn't pay the interest over, to me, that's just not right. And then just on a lighter note, in terms of the fees, you charge 5,000. I'm a member of SACA. We charge 10,000. So maybe you should double your fees. But just in terms of the fund, the Fidelity Fund, can you not add a certain percentage to that goes to you people? Is that not part of the way to get a funding model? Thank you.
Thank you, Chair. I just want to answer the administration part. On the funding model, this is we are in the initial discussions on the funding model. I'm not sure if you are aware, in the Attorneys Act, when the interest was collected, 12.5% went to the regulation, and this is something that was scrapped when the LPA was introduced. And we are thinking that we need to have a serious discussion with the fund and the minister to bring back, because that could certainly ease our capacity problems and our funding problems. But I will ask Ignatius to answer all the other questions. Thank you, Chair.
Okay, I hope I noted them all. Let's firstly start with the problems at the judiciary. I think there's a major issue with the capacity of the judiciary. And I was very happy to see the media reports that the President has now actually awarded budgetary control to the judiciary. The fact of the matter is that there's been very little growth in the capacity of judges, or the number of judges, in the last 30 years. And it's just not kept up with the pace. So I think that is a prime area to start in capacitating the judiciary, rationalizing possibly where the courts are sitting. And I know JPM Lambu has made recommendations that there be a separate High Court established, for example, on the West Rand, to deal with, I mean, West Rand, you're talking about mines, etc., all of those currently going to Johannesburg. So the capacity there needs to be looked at. The one thing, and it's maybe not going to resolve the issue, but if I can abuse the opportunity, the state, the physical state of the court buildings is a complete disaster. And I think Public Work needs to start explaining why these places are not maintained. Johannesburg High Court, for example, is actually a serious fire risk. But that's just as a side issue. On resolving the issues at the RAF, again, I don't really think it's the LPC's place to say, but if I may venture, capacity is a serious issue. It has been an issue probably for the last 20 years. I remember I think I left there about 5 years ago. For the preceding 15 years, the claims officers had been sitting with file counts of around about 1,000 files. The capacity is not there, and that is very closely linked to the funding model. If you think about the fact that the funding comes from the fuel levy alone, I don't think the fuel levy can continue sustaining the growth in claims. And I don't think there's much of a dispute about that. So the funding model needs to be looked at. Obviously, the administration and management needs to be improved again, get proper processes in place, make sure that claims are assessed and investigated. I mean, there's numerous cases where the courts have said it is the duty of the RAF to investigate a claim. But that's not happening for whatever reason. So let's start there. Let's start investigating those claims. And you are going to curb this issue about the escalation of the settlement amounts. You're going to curb the issue of the fraudulent claims and the abuse of the system if the RAF simply properly investigates. Okay, yes, the duplicate payments. So can I just explain to you what happens, right? When an RAF attorney, a claimant attorney, receives money from the RAF, they don't get one payment per matter. The RAF makes a bulk payment, and very often the associated remittance is not provided at the same time. Yes, for firms that are smaller and don't have a lot of matters, it should have been possible for them to see that I'm getting money in that I shouldn't be having. If you have a substantial practice, and let me not mention the firm's name, but there's a firm that we're currently busy with suspension and striking proceedings. We uplifted in excess of 6,000 files from that firm, RAF claims. Now, if you're dealing with that volume of RAF claims and you get a payment of 10 million into your trust account without an associated remittance, you will not know what that payment is for. And then what you are expected to do is to retain those funds in trust until you can establish who the funds belong to. You're not allowed to touch it, right? And that's where the guys that we've been suspended and struck fell short. They touched that money. If you cannot identify, it must remain there.
Interest.
So I think I did address the issue about the interest earlier, and I think Mr. Pachane also addressed that. I think it's something that we do need to speak to SIU about to see if there's legal recourse for the recovery of the interest. The fact of the matter remains, as long as the money is in trust, that interest by law goes to the LPFF. Is that it?
Honorable Beesley, I thought maybe you're done.
Am I?
No.
Chair, I'm a disciplined member, so how
Thank
much
you.
time have I got left?
Thank you very much. Okay.
Now, just some of my questions weren't answered. They're simple questions. You know, does every accident lead to a claim? How's it calculated? And then just a question I didn't ask. You know, do we know how many RAF matters are enrolled in the legal system at the moment?
Right. The number of matters enrolled in the legal system, I wouldn't be able to give you an answer. I can give you probably at a later stage a rough idea in terms of Gauteng, because there's very decent stats kept, but I don't have that answer. Whether all accidents lead to RAF claims, right, so that answer is maybe a little bit more complicated. So you need to distinguish between personal injury claims and your medical, your claims for medical costs. So you might have instances where minor accidents there would be, supplier claims. It used to be called supplier claims. So this guy goes to the hospital, it might be a bit of a bruise, and he gets treated and given some paracetamol, and he gets sent home. Those could lead to supplier claims, and those are small amounts depending on the cost of the medical treatment. For other injuries sustained in accidents, there you need to distinguish between your general damages and the loss of earnings, right? Now we're not talking about deceased victims, right? On general damages, how that is calculated. Firstly, the RAF brought in, I think it was in 2008, the Amendment Act. And the idea was, I remember there was a CEO at RAF who used to always talk about the shame money. Okay, so most motor vehicle accidents led to whiplash injuries. We all know what a whiplash injury is, and those usually used to settle in the region of 40,000. So the RAF felt that those, it was called shame money because actually it was felt that that person, there's nothing wrong with the person. So the idea was introduced to say, let's look at only compensating for serious injuries. Okay, and then there's a process to assess whether somebody is seriously injured. It's a link to the American Medical Association formulas that looks at the whole person impairment. So a medical assessment needs to be done from top to bottom, looking at the injuries, the effect of the injuries, and the potential future effect of the injuries. Okay, if your impairment reaches 30% or more, then you become entitled to general damages. There is a process, as I alluded to earlier, where the HPCSA by law has established an RAF appeal tribunal, which consists of medical practitioners who need to assess if there's a dispute about the seriousness of the injuries. And at that tribunal, a lot of the assessments have been turned down to say, but in as much as the doctor might have said it's more than 30%, it is actually not. The quantification of those damages, we used to call it the vleislijst, right? So it's a little booklet by Koch, looking at various judgments over the years where the courts have awarded damages for general damages, and then those get escalated by inflation, etc., and adjusted for amendments in the court awards, and that does become quite costly, right? And maybe just to comment on what you had indicated earlier, those brain injuries is a very, very difficult area to deal with. Very often, the brain injury that is sustained is not, or the effect of that is not apparent immediately. It might be that in many years' time, the injury starts causing negative effects. I do think I to some extent agree with you. You would see cases where the child is from a very impoverished background, and then the industrial psychologist comes and says, but this child would have become a mathematician or a rocket scientist, whatever you want to call it. And yes, the possibility is there, right? But realistically speaking, from a socioeconomic background, it's unlikely. And then what the courts do is to adjust for the contingencies, okay? So yes, there's a percentage possibility for you to have become this medical doctor or whatever. Let's say maybe that's 50% possibility. And now let's look at your current circumstances. They do all kinds of very nice actuarial calculations to come up with a contingency or the likelihood of the person having become that versus the possibility at the present stage. So it becomes very convoluted. And those tend to be the higher part of the costs or the damages that are awarded is the loss of earnings. Okay.
Thank you very much, Honourable Beesley. Honourable